The Factories Act, 1948, Act No. 63 of 1948, Chapter 9, Special Provisions, 89. Notice of certain diseases. 1. Where any worker in a factory contracts any disease specified in the third schedule, the manager of the factory shall send notice thereof to such authorities and in such form and within such time as may be prescribed. 2. If any medical practitioner attends on a person who is or has been employed in a factory and who is or is believed by the medical practitioner to be suffering from any disease specified in for the third schedule, the medical practitioner shall without delay send a report in writing to the office of the chief inspector stating A. The name and full postal address of the patient, B. The disease from which he believes the patient to be suffering, and C. The name and address of the factory in which the patient is or was last employed. 3. Where the report under subsection 2 is confirmed to the satisfaction of the chief inspector by the certificate of a certifying surgeon or otherwise that the person is suffering from a disease specified in the third schedule, he shall pay to the medical practitioner such fee as may be prescribed, and the fee so paid shall be recoverable as an arrear of land revenue from the occupier of the factory in which the person contracted the disease. 4. If any medical practitioner fails to comply with the provisions of subsection 2, he shall be punishable with fine which may extend to 1,000 rupees. 5. The central government may, by notification in the official gazette, add to or alter the third schedule, and any such addition or alteration shall have effect as if it had been made by this act. 90. Power to direct inquiry into cases of accident or disease. 1. The state government may, if it considers it expedient so to do, appoint a competent person to inquire into the causes of any accident occurring in a factory or into any case where a disease specified in the third schedule has been or is suspected to have been contracted in a factory, and may also appoint one or more persons possessing legal or special knowledge to act as assessors in such inquiry. 2. The person appointed to hold an inquiry under this section shall have all the powers of a civil court under the Code of Civil Procedure, 1908, 5 of 1908, for the purposes of enforcing the attendance of witnesses and compelling the production of documents and material objects, and may also, so far as may be necessary for the purposes of the inquiry, exercise any of the powers of an inspector under this act, and every person required by the person making the inquiry to furnish any information shall be deemed to be legally bound so to do within the meaning of Section 176 of the Indian Penal Code, 45 of 1860. 3. The person holding an inquiry under this section shall make a report to the state government stating the causes of the accident or, as the case may be, disease, and any attendant circumstances, and addition any observations which he or any of the assessors may think fit to make. 4. The state government may, if it thinks fit, cause to be published any report made under this section or any extracts therefrom. 5. The state government may make rules for regulating the procedure at inquiries under this section. 91. Power to take samples. 1. An inspector may at any time during the normal working hours of a factory, after informing the occupier or manager of the factory or other person for the time being purporting to be in charge of the factory, take in the manner hereinafter provided a sufficient sample of any substances used or intended to be used in the factory, such use being A. In the belief of the inspector in contravention of any of the provisions of this act or the rules made thereunder, or B. In the opinion of the inspector likely to cause bodily injury to or injury to the health of workers in the factory. 2. Where the inspector takes a sample under subsection 1, he shall, in the presence of the person informed under that subsection unless such person willfully absents himself, divide the sample into 3 portions and effectively seal and suitably mark them, and shall permit such person to add his own seal and mark thereto. 3. The person informed as aforesaid shall, if the inspector so requires, provide the appliances for dividing, sealing and marking the sample taken under this section. 4. The inspector shall A. Forthwith give one portion of the sample to the person informed under subsection 1. B. Forthwith send the second portion to a government analyst for analysis and report thereon. C. Retain the third portion for production to the court before which proceedings, if any, are instituted in respect of the substance. 5. Any document purporting to be a report under the hand of any government analyst upon any substance submitted to him for analysis and report under this section, may be used as evidence in any proceedings instituted in respect of the substance. 91A. Safety and occupational health surveys. 1. The Chief Inspector or the Director General of Factory Advice Service and Labour Institutes or the Director General of Health Services to the Government of India or such other officer as may be authorized in this behalf by the state government or the Chief Inspector or the Director General of Factory Advice Service and Labour Institutes or the Director General of Health Services may, at any time during the normal working hours of a factory or at any other time as is found by him to be necessary, after giving notice in writing to the occupier or manager of the factory or any other person who for the time being purports to be in charge of the factory, undertake safety and occupational health surveys, and such occupier or manager or other person shall afford all facilities for such survey, including facilities for the examination and testing of plant and machinery and collection of samples and other data relevant to the survey. 2. For the purpose of facilitating surveys under subsection 1, every worker shall, if so required by the person conducting the survey, present himself to undergo such medical examination as may be considered necessary by such person and furnish all information in his possession and relevant to the survey. 3. Any time spent by a worker for undergoing medical examination or furnishing information under subsection 2 shall, for the purpose of calculating wages and extra wages for overtime work, be deemed to be time during which such worker worked in the factory. Explanation. For the purposes of this section, the report, if any, submitted to the state government by the person conducting the survey under subsection 1 shall be deemed to be a report submitted by an inspector under this act.